Good morning, everybody, and welcome to this morning's webinar. For those of you who don't know me, my name is Mark Foxcroft. I'm a partner in the Housing Management and Property Litigation Department here at Devonshires, and I'm joined today by my colleagues, Stavrina Tofallis, who is the Head of Development Sales, and Dominic Bauers, who is a solicitor in the Real Estate Projects Department. And today we're going to have a look at the new form of shared ownership leases that were released in May of this year. Dominic's going to take us through some of the real detail because he's done a proper deep dive into the leases, and he's going to highlight some of the real key sections. Then I'm going to have a look at some management issues that we think that clients will need to consider, and which we've already been asked about by clients. And I'm also going to just have a little refresher about shared ownership management, some of the things that haven't changed and will still apply to these new model leases, just so everybody has got that at the forefront of their minds. And then Stavrina is going to have a look at some practical considerations to deal with implementing the new lease at the end. So hopefully the presentation should run to about 45 minutes, and then we'll have 10-15 minutes for your questions. So if you do have a burning question as things go on, please feel free to type in the box. And we will pick them up at the end. Before I hand over to Dominic, just a little bit of housekeeping. As ever with our webinars, you will have a copy of the slides sent to you in PDF format at the end. So you've got that as a resource. As I've already mentioned, please use the Q&A button to ask any questions. And we would really appreciate it if you took the time to fill in the feedback survey after the webinar. It helps us get a feel for how the presentation has gone. And most importantly, it canvasses any topics that you'd like to hear from us in the future on. And indeed, that is how we have historically shaped our webinar programs. So if there is anything you would require or would like to see some content on, please let us know via the feedback survey. So without further ado, I'll hand over to Dominic.
Right, good morning, everyone. Homes England published the new form of model shared ownership house and flat leases for homes provided through the 2021 to 2026 Affordable Homes Programme, which I'll abbreviate to AHP 2126 going forward, at the end of May this year, and updated them again at the end of September. So where can you actually find the new forms of model lease? They are to be found in section 11 of chapter 1 of the Capital Funding Guide, which I'll abbreviate to CFG. And for the first time, there are also model leases for shared ownership homes provided in designated protected areas and for older persons shared ownership. There are also separate key information document packs set out at section 11.3 of the CFG, comprising 3 separate documents to be completed and provided by registered providers, which I'll abbreviate to RPs, in connection with the sale of new shared ownership homes. And there are 4 different versions of the key information documents. There's one for standard shared ownership, there's one for designated protected areas, one for older persons shared ownership, and one for home ownership for people with long-term disabilities. So when do we have to start using the new forms of model lease? The new model leases must be used for all shared ownership homes funded through the AHP 2126, including homes funded from the 1st of April using receipts from the Voluntary Right to Buy programme, with recycled capital grant funding during the AHP 2126 period, shared ownership delivered as part of rural affordable housing, older person shared ownership, and home ownership for people with long-term disabilities, and right to shared ownership. And additionally, and subject to transitional arrangements, with effect from the 28th of June 21 for all shared ownership homes delivered through the Section 106 planning system. Now, important to note that these transitional arrangements are not actually set out in the Capital Funding Guide. They were set out in a written ministerial statement dated the 24th of May 2021. And having spoken recently to Homes England, they're quite keen to point out that these transitional arrangements for Section 106 schemes are the government, not Homes England. They've sort of made a distinction so that any changes to the transitional arrangements aren't, strictly speaking, going to come through Homes England or through the CFG. So what are these transitional arrangements and why are they in place? They've been agreed to ensure, as far as possible, that the planned pipeline of delivery will not be adversely impacted. Now, number one, the new shared ownership model will not apply to sites with full or outline planning permissions already in place or determined, or where a right to appeal against non-determination has arisen before the 28th of December 2021 or the 28th of March 2022 if there has been significant pre-application engagement. In addition, local plans and neighbourhood plans that have been submitted for examination before the 28th of June 2021 are not required to reflect the new shared ownership policy requirements. And local plans and neighbourhood plans that have reached publication by the 28th of June will not be required to reflect the new shared ownership policy requirements as long as they are submitted for examination before the 28th of December 21. And where local and neighbourhood plans are adopted under these transitional arrangements, the new shared ownership requirements will not need to be applied when considering planning applications in the plan area until such time as the requirements are introduced by the government through a subsequent update. Now, the government has said that it will continue to monitor the effectiveness of these transitional arrangements in light of emerging economic circumstances, and Homes England has confirmed that as of today's date, no changes have been made to the transitional arrangements. So what are the new requirements? I'm going to work through in sort of order of importance. So firstly, key information document pack. RPs must complete and supply the key information documents as set out in section 11.3 of the CFG to both the prospective shared ownership buyer to ensure that the buyer can make an informed decision. And it's actually a condition of grant funding that these documents are completed and provided to the buyer no later than at the reservation stage. And they have to be provided to the buyer's solicitor with the memorandum of sale. And the RP must obtain confirmation from the solicitor that the buyer has received them. So there are three key information documents. Number one, key information about the home. Number two, summary of costs of the home. And number three, key information about shared ownership. And these documents themselves detail the stage at which they should be provided to the prospective buyer. Now, obviously, RPs will have to update their admin and sales procedures to comply with this important new requirement, and in particular to ensure compliance with the specified timescales. Next change, mortgagee forfeiture notification proviso. Now, this has always been a standard clause in the shared ownership lease, but it's now been upgraded to be one of the so-called fundamental clauses. In summary, this clause requires that if a tenant has breached the lease, the RP must notify the tenant's lender before taking any proceedings either to forfeit the lease or to take possession proceedings, and give the lender 28 days to confirm that the lender will remedy the breach and a further 28 days to remedy such breach. RPs will be familiar with the requirement of having to give shared ownership buyers lenders a written undertaking at the start of sales in this form, but including it as a fundamental clause may mean that in practice the undertaking is no longer necessary depending on lender requirements. The next change relates to estate rent charges created on final staircasing. Now, if a formal statutory estate rent charge is created by the transfer that's completed on final staircasing of a shared ownership house lease, the transfer must expressly exclude the remedies contained in section 121 of the Law of Property Act 1925. RPs will have become familiar with this requirement by shared ownership buyers, lenders, and will therefore need to ensure that when actually acquiring plots from commercial developers in the first place, the terms of the original transfer to the RP also contains the same exclusion. Next change relates to the RP's surrender and resale nominations period, which has been reduced from 8 weeks to 4 weeks. RPs will need to ensure that their admin procedures are adapted as necessary to be able to comply with the reduced timescale, especially where there's a nominations agreement in place with the local authority. And future nominations agreements will also have to be negotiated and drafted so as to enable compliance with this shorter timescale. The next change, the minimum initial equity share has been reduced from 25% to 10%. The minimum standard staircasing equity share has been reduced from 10% to 5%. And the minimum lease term for the new prescribed form of shared ownership lease is now 990 years. Now, this is obviously going to have significant implications for RP's site and plot acquisitions when acquiring leasehold property. And it seems likely and inevitable that 999-year head leases will become the industry standard. Now, the CFG expressly states that there are no exceptions to the policy of 990-year shared ownership leases, but Homes England has clarified that any shared ownership lease granted pursuant to the new right to shared ownership provisions does not have to be for a minimum of 990 years if the landlord's own title is leasehold and is for less than 990 years. The next major change is the introduction of a 15-year optional 1% staircasing procedure and a new valuation method. These new requirements are set out in Schedule 10 of the flat lease and Schedule 7 of the house lease. The 1% staircasing period is defined as a period of 15 years from the later of the lease date and the date on which the lease is assigned to a new shared ownership tenant. So it's important to note that this new 1% staircasing offer must be available to shared owners for a minimum of 15 years. That is, a full 15-year period of 1% staircasing must be available on all new shared ownership homes, and a new 15-year period must be offered to new shared owners on resale of such homes. So during the 1% staircasing period, in addition to and in combination with the usual standard staircasing provisions, shared ownership tenants will have the option to buy a maximum of 1% equity each year. Shared owners will not, however, be able to roll over or accumulate the new 1% staircasing offer to purchase in future years. It is limited to a maximum of 1% each year. So what's the procedure for this 1% staircasing? Number one, every year prior to the usual rent review date, the RP must serve a notice, valid for 3 months, on the shared ownership tenant, stating how much 1% equity will cost that year. And the model leases do contain a suggested form of notice. If that notice and valuation expires, the shared ownership tenant can request an updated valuation, and the RP has 14 days to provide it. If the valuation is disputed, then either the RP or the shared ownership tenant, via a request to the RP, can at their own cost obtain an independent RICS valuation, and the RP must serve a new notice stating how much 1% equity will cost that year on the shared ownership tenant within 7 days of determination. The shared ownership tenant then has 3 months from the date of the agreed valuation to pay for the 1% equity share. A staircasing memorandum is completed and must be attached to both parts of the lease, and the new model leases contain a suggested form of memorandum. Now, the valuation method is a little bit complicated. In simple terms, the price of each 1% equity share will be based on either A, an estimated open market valuation of the property, or if disputed by either party, an independent open market valuation of the property carried out by an RICS valuer at the cost of the party requesting it. In each case, adjusted each year upwards or downwards in line with local house price inflation, which I'll refer to as HPI. The valuation formula is expressed as X times Z over Y, where X is 1% of the full open market value of the property at the relevant time. Y is the relevant base monthly HPI index figure, and Z is the relevant latest monthly HPI index figure. RPs are prohibited from charging admin fees on 1% equity shares bought as part of this new staircasing model. And now we come to perhaps the most significant change. It's the initial repair period. Now, during the initial repair period, the RP must support the shared owner with the cost of repairs and maintenance, both internal non-structural and external structural. The initial repair period is defined as the period of 10 years from the date of the lease, or if shorter, a period from the date of the lease to the date of final staircasing. Homes England has, however, clarified that the initial repair period for any rented homes that become shared ownership under the right to shared ownership procedure exercised in the future, that period will be 10 years from the date of practical completion of the property in question. So everyone's talking about this being a 10-year obligation, and looking, the worst case scenario, that's the longest it could be, but don't forget that it could be shorter than 10 years. As soon as a shared owner staircases to 100%, the initial repair period obligations fall away. Obviously, that in itself could cause a problem, because you could have a site of many units, some of which remain shared ownership and within the 10-year repair period, some of which have staircased and are no longer subject to the repair period. So that will no doubt introduce some significant admin issues. But the good news is that following the expiry of the initial repair period, the purchaser will assume full responsibility for all repairs and maintenance and all service charge contributions in accordance with the usual terms of the flat or house lease. So during the initial repair period, the standard repair obligations of the RP and the shared ownership tenant, and calculation of the service provision, and therefore the service charge payable, and this can also apply to houses where the house lease contains full service charge provisions, are subject to the new requirements set out in Schedule 9 of the flat lease or Schedule 6 of the house lease. And these can be summarised as follows. Firstly, internal non-structural repairs. Provided that the RP, acting reasonably, assesses in advance of such works being carried out that they're essential and genuine works, which are the shared ownership tenant's responsibility under the lease and which are not the result of the shared ownership tenant breaching its lease, the shared ownership tenant can apply to the RP for a financial contribution of £500 per year of the lease term, plus the amount of any unused contribution from the previous year that has been rolled over towards the costs incurred by the shared ownership tenant for any of the following works, all of which have to be carried out by an approved service provider. So the works are keeping in repair and proper working order the installations in the flat or house for the supply of water, gas and electricity, and for sanitation, including basins, sinks, baths and sanitary conveniences, but not other fixtures, fittings and appliances for making use of the supply of water, gas or electricity, and space heating and heating water. An approved service provider can be either the RP's own internal repair service or direct labour organisation, or an approved tradesperson from the RP's approved panel, or at the leaseholder's discretion, a Trustmark approved tradesperson. This £500 contribution does not apply to any work covered under a warranty, insurance policy or guarantee. Normal cyclical health and safety requirements, e.g. annual gas servicing or electrical testing. Decoration works which the shared ownership tenant is obliged to carry out under the terms of its lease. Improvement works or any works required as a result of any breach of the shared ownership tenant's lease covenants. Now, finally, moving on to external structural repairs, and having kept abreast of the consultation procedure and the response, this didn't seem to be referred to in the government's original proposals. And it's potentially a considerable additional financial and admin burden on RPs that goes far beyond the £500 a year allowance for minor internal non-structural repairs. So the obligation is the RP must provide or procure the provision of essential repair works notified to the RP by the shared ownership tenant during the initial repair period at no cost to the shared ownership tenant, including not requiring the shared ownership tenant to contribute to the cost of any excess or admin fees payable under the terms of any new build warranty or buildings insurance policy in relation to any claim made by the RP. This will cover works to the load-bearing framework of the building in which a flat is located or the house itself, the external fabric of the building or the house, all other structural parts of the building or the house, including the roof, foundations, joists and external walls, and the service media and machinery and plant within, but not exclusively serving the flat or the house, and all parts of the building or the house which are not the responsibility of the shared ownership tenant. But importantly, this does not cover any normal general maintenance, redecoration and renewal works. Now, this has an inevitable impact on service charges and reserve and sinking funds. Now, Schedule 9 of the flat lease and Schedule 6 of the house lease state no reserve fund contributions will be used towards the cost of external and structural repairs, but this does not prevent the landlord from collecting a contribution towards a reserve fund during the initial repair period, if allowed under the terms of the lease, provided it is not used or intended to be used towards external and structural repairs. And the CFG states, in calculating the annual sinking fund charge, landlords should not factor in any external and structural repair work, expected or unexpected, within the first 10 years. Sinking fund contributions cannot be used for any works expected or unexpected within the first 10 years. Homes England has, however, recently confirmed that while the costs of such external and structural repairs cannot be factored into sinking fund charges for the first 10 years, estimated costs beyond that period can be included, and the shared ownership tenant can be required to pay any such sinking fund charges from the beginning of the lease. So it's all rather complicated and involved, but that brings to the end my summary of the changes to the lease. And now I'm going to hand over to Mark, who will investigate some of the practical issues.
Thanks, Dom. That was really interesting, and I think segueing into the management issues, the last point you made there is the real vital one about how complicated it is going to be for RPs to effectively and properly manage their service charge accounts, budgeting and reserve funds, and that's something I'm going to have a look at now. But on this first slide, I've just put up a few things where we've had comments and questions from clients already who've been looking into this, and I just thought I'd put them up because they're quite an interesting kind of example of the issues that people are thinking about. So the first one is they're coordinating the repair-free period. So, clients ask us, will the 10-year period be the same for all leases on the same scheme? Now, Dom has happily clarified there that it is going to run from practical completion of the relevant property. But obviously, if you've got blocks, you've got schemes with different blocks that come online at different times, then you're going to have potentially different initial repair periods for different leaseholders in different blocks, which then makes your future planning and your depreciation allowances and things like that all the more complicated. So that's one thing that we've been looking at, and as Dom also touched on, the service charge debts are likely to be reduced, hopefully, because there are no major works costs being passed down to the leaseholders in the first 10 years, and then hopefully they shouldn't get into so much service charge arrears. And indeed, I think that's probably part of the government's thinking. We also, that means that you won't have to do as much consultation under Section 20 of the Land on Tenant Act 1985 in the first 10 years. So there is a slight lack of administrative hassle there, but I think it is much way outweighed by all the other things that RPs are going to have to be considering. The next point, is important to note that the leaseholders will still be charged for services. It is only the structural and non-structural internal repairs which are caught by the initial repair period. So the usual service charges that relate to the provision of cleaning, the provision of gardening, grounds maintenance, those kind of things, they still will be charged and they will be service chargeable. So it's not the case that they won't pay any service charge in the first 10 years. And flowed on from that, because there are less service charges being paid, hopefully some clients thinking there may be less challenges to service charges. However, I suspect, unfortunately, particularly as this is being bedded in over the next few years, that is sadly not going to be the case. I think it's going to be quite the opposite. I think we're going to see much more challenges as landlords will unfortunately get it wrong, or the tribunal and the courts will have to interpret the leases and the new model form of leases. So unfortunately, I think we're going to be looking at potentially more service charge admin, and particularly on mixed tenure estates. And that's my next slide. Thank you, Stavrina. So as I say, I think one of the issues that occurs to me is going to be how the initial repair period works on mixed tenure blocks and estates. So where you've got blocks where you've got long leaseholders or potentially general needs tenants, as well as shared owners using the new lease, I think there's going to be real issues in the administration of the service charges, because those long leaseholders who contribute to the estate costs or the block costs will be required to do so in the normal fashion. So they will, from the commencement of the lease, they will be required to contribute towards the service charges for major works, external repairs, and they'll be required to contribute to a sinking fund. But you can already see the administrative problems that will arise with that. I mean, in my experience, RPs do have difficulty with service charge accounting. It can be very difficult, particularly on complicated estates. And I think this is going to firmly fall within those issues, because you're going to have make sure that these shared ownership leaseholders are not being passed costs and not being asked to contribute towards service charges, sinking funds and reserve funds for costs which relate to the first 10 years. So that's going to be very difficult to do, I think. The next slide is another issue which I think, unfortunately, from being a litigation practitioner, I can foresee is going to be a fertile ground for disputes between leaseholders and landlords, is the internal repair allowance. When Dominic was going through the detail, he referred to the essential and genuinely essential and necessary repairs. Who decides what repairs are necessary and essential? You can already see that what a leaseholder's perspective of what is necessary and essential may well differ to a landlord's. And also, although there is a lot of detail about what the internal repair allowance relates to, installations and things like that, sometimes it's not quite straightforward as that in practice. And it can be that, something is causing damage to something else. And, things like damp and mold, which may be exacerbated by tenant use, and can be very expensive to fix. Does that fall within the internal repairs? You have to identify what's causing the damp if it's being exacerbated. And I think we can just see, in those of us who work in disrepair area of law or fitness for human habitation legislation, I can just see that there is going to be a lot of dispute as to getting these repairs done. Leaseholders using their own contractors, although they may be Trustmark approved. The landlord maybe would much prefer to use their own contract for obvious reasons. So I think that's something that we're going to have to keep an eye on. But I've said at the bullet point, I think our Ps, at the bottom, I think our Ps need to be looking to put in place robust policies that deal with this in advance, so can make sure that they are ready to deal with this, because otherwise it's going to take a huge amount of frontline staff's time dealing with these disputes and dealing with these issues. So good policies, good procedures is going to be crucial, as is training, I would suggest, to the frontline staff. So those are the things that have immediately and already kind of been flagged up to us, jumped off the page to us as to the big changes and the impact it's going to have on the day-to-day management. But I think it's also important to bear in mind that a lot of what's going to stay the same in terms of practical management of shared ownership properties. So the point is, if you just move on to the next slide, please, Stavrina, thank you. So as you can see there, those of you who are familiar with shared owner, you may well have heard of the Richardson versus Midland Hart case, which goes back to 1997, but it was a case of crucial importance, because what the court found was that a shared ownership lease is in fact a form of assured short hold tenancy. It's a fixed term tenancy, albeit of a very long term. Previously it was probably 99 years. Now it's going to be 990 years, but it is still an assured short hold tenancy, because they don't own the entirety of the leasehold interest. As I've put there at the top bullet point, a tenant is not capable of holding a leasehold interest until they hold 100% of that lease. So it can't be a leasehold interest. It has to be a form of tenancy. And the court found that the type of tenancy it was an assured short hold tenancy. So that's what shared ownership leases are, and that means they fall within the statutory regime for assured tenancies, which is laid out in the Housing Act 1988. So why is that important? It's important because it fundamentally changes how you seek possession of a shared ownership property in circumstances where there have been breaches of the lease, whether that's a failure to pay rent, a failure to pay service charge, or just breach of the tenant covenants. The whole process is completely different, as we can see from the next slide. So, as I said at the middle bullet point there, the appropriate way to take action against a shared ownership leaseholder for breach, for failure to pay rent, or whatever the case may be, is to go via the statutory process laid out in Schedule 2 of the Housing Act 1988 and rely on some of those statutory grounds for possession. Whereas for a long leaseholder, you would forfeit that lease via the forfeiture clause in that lease, and then proceeding on that basis, which is quite a bit more straightforward. For assured tenancies, you have to, because they have statutory protection, you have to go on the statutory grounds for possession. So that would require you, where there is a breach of lease, in the first instance, to serve a notice of seeking possession, or a NOSP, pursuant to Section 8 of the Housing Act 1988. And within those notices, you have to put in the grounds upon which you rely. So if we have a look at the grounds now that landlords would tend to rely on against shared owners, we have grounds 8, 10 and 11, which all relate to a failure to pay rent. That's obviously shared owners pay a specified rent based on the unowned proportion of the leasehold interest. So a failure to do that, to pay that specified rent, is a breach, and it puts you into one of the or more of the grounds of possession. So you've got ground 8, which is the mandatory ground for possession, which means that if that ground is made out, the court must make an order and has no discretion. And that, as long as at the date of the hearing and the date that you originally served the notice, there are 8 weeks or 2 months rent, if rent is paid monthly, is unpaid, then you'll get an order. And then you've got ground 10, which is if some rent is lawfully due but is unpaid. That is a ground for possession, but the court does retain a discretion as to whether or not to make a possession order. It has to be considered it's reasonable, and that can be quite a high hurdle to get over for shared owners. But we often do rely on ground 10 if ground 8 is not made out, and then ground 11 is persistent delay in paying rent, and ground 12 is if a clause or a covenant or an obligation of the tenancy other than the payment of rent has been broken or not performed by the tenant, then you can rely on that. And the reason that is important is because under the model shared ownership lease, the payment of service charge is not reserved as rent, as often service charges are reserved as rent under a lease, but because they're not reserved as rent, then they aren't rent, and it is a separate contractual obligation to pay the service charge. So a failure to pay service charge would be a breach of covenant, and you'd have to rely on ground 12. So it's important to establish when you are seeking possession against a shared owner, whether you are going on rent or service charge or both, and make sure you include all of the relevant grounds going forward. Yeah, so that slide just basically reiterates what I've just said, that service charge is not reserved as rent in the model shared ownership lease, so you would be looking to rely on ground 12 for a breach. And the other important thing that I wanted to talk about in terms of practical management of shared ownership leaseholders is the role of the lender. Now, as Dom said in his area of the talk, the mortgagee protection clause, which has been in the model form of lease previously, but is now been made a fundamental clause and has been amended quite significantly, is going to be very important when you're looking to potentially seek possession against a shared owner. And as Dom said, you are required to engage with the lender and give them notice and allow them the opportunity to remedy any breach by the tenant. And if you don't do so, you will prejudice your possession claim. And the reason for that is because obviously the lender's security is tied up in the property. And if you seek possession and get a possession order from the court as a landlord, if that is successfully obtained and executed, the lease ceases to exist, it falls away. So the lender's security would evaporate. And that's why they're keen to avoid possession action. And indeed, as well as the mortgagee protection clause, there is detailed guidance about handling arrears and possession sales in relation to shared ownership properties between the Council of Mortgage Lenders, Homes England, and the National Housing Federation. And I've put the link to it there. Not sure if it's going to be updated, but historically it has been a very useful tool for those practitioners such as myself who deal with shared ownership repossession. So it's always very important to liaise with the lender, most commonly because they will often pay off us a shared ownership's leaseholders arrears of service charge or rent arrears in order to remedy the breach and avoid no further action is taken. And then they'll just add it to the mortgage debt if there's sufficient equity. So you have a vested interest in contacting them in the first instance in relation to arrears, because it will likely mean the arrears get paid. But if there is there is a significant breach, let's say it's nuisance or antisocial behaviour that's ongoing, or the arrears are such a level that the lender isn't prepared to pay back the money, you would have to serve a notice seeking possession and then issue a claim upon expiry of that notice. And our advice is to always ensure that you're keeping the lender involved at all points to avoid any potential issues down the line. But as Don was saying, clause 6.2.3 of the shared ownership model lease, which is the mortgagee protection clause, it makes it a contractual obligation on the landlord to give the lender 28 days notice that it intends to commence proceedings and allow them the opportunity to remedy that breach. So as I say, it is a contractual obligation to involve the lender. So make sure that is being done if possession is being considered. And then if you do end up going to court, you must ensure that you serve the possession on them. That is a court requirement, and you have to inform them of the first hearing date, because, as I say, they will be able to kind of sweep in and overturn your possession proceedings and any possession order if they haven't been properly engaged, because they need to be given the opportunity to potentially seek their own possession order against the leaseholder and get their money back in that way. So that's just a bit of a whistle-stop tour as to, let's say, some of the history of shared ownership, and just keep it in the forefront of your mind that although we have a new form of lease, the legal interpretation of possession and how you go about that is still likely to remain the same. But as I say, I think where we're going to be seeing a lot of potential litigation is around the administration of the initial repair period in relation to service charges, sinking funds, and the internal repairs allowance. So I'm going to hand over to Stav now to finish off with some practical considerations, and then I can see we've had a number of questions in, so we'll try and get through a few of those.
Thanks, Mark. So I'm sure you've already been thinking about how to implement the new forms of lease and the new requirements contained in them. But I thought it would be helpful just to flag a few questions and considerations that you need to sort of bear in mind when doing this. So the first one is which form of lease to use. So Dominic previously sort of explained when the existing form and when the new form needs to be used. But there are those transitional periods. There are occasions where, for example, you can use the existing form, but you need to consider, do you want to use the new form? So, for example, if you've got a site where it's being done in phases, and the first phase is the pre-21-26 grant funded, you don't have to use the new form of lease. But if the second phase will be within the 21-26 grant funded site, then do you want to use the new form of lease on phase one so that it runs through all phases? So it's things like that that you need to consider. And it's really important that when we're instructed to deal with the site setup, not only do you let us know whether it's the pre-21-26 grant funded site or whether it's a 21-26 grant funded site, but also which form of lease you want to use. Of course, if it's a 21-26 grant funded site, then we only have the option to use the new form. But it's those transitional sites that we just need clarification on, and you need to just think commercially about what's best for you and that particular site. The second practical consideration are your lease precedents. So, for example, most of our clients, although they use the new form of shared ownership lease, we've got tweaks here and there to make them particular to what our clients' needs are. Who will be drafting these for you? Will you be doing them in-house? Will you be asking Devonshires to do them for you? Do you have another legal advisor that you want to get involved in doing them for you? Will you change your existing precedents to line up with certain aspects of the new form? These are all things that you need to consider, and sort of let us know if there is anything that we can do for you. If you'd like us to update your precedents, if you'd like us to draft your new form of lease for you, we're more than happy to do so. If you just let us know, then we can take that into consideration. If we've already got you drafted your existing precedents, then we can use the information that we've got within those to make sure that it marries on through. For example, any covenants that you've specifically asked to be in the existing precedents, we'll make sure that those follow through to the new form as well. The 1% staircasing requirement. So this in practice is potentially going to cause some headache in relation to how this will be dealt with practically. Again, is this something that you will just deal with in-house going forward? Will you have your own processes that you can just deal with it internally? Will you be instructing solicitors? I know one topic of conversation has been about new technology. Is there some sort of app that people can pay through that and make the process much smoother? Because, of course, it's going to be a lot more admin dealing with 1% staircasing, as this is something that leaseholders can do much more often. So it's these sorts of things that you need to consider. How do you want to deal with that in practice? Is it something that you want us to instruct us to deal with? Or is it something that you can come up with ways in-house that you can deal with this and make the admin side sort of slightly easier for yourselves? And then finally, the 10-year repairing obligation. Is this going to be problematic to administer? I know that both Mark and Dominic have touched on this already. It seems as though the government response assumes that the RPs will be able to take these new obligations in their stride and use the same approach as currently used for affordable rent properties. But do you think that will work for you? For example, I know that both Mark and Dominic explained about the 10-year repair obligation ending once final staircasing takes place. So, for example, if someone final staircases after 5 years, you're no longer obligated with the repair obligations. How will you keep track of that? How will you make sure that you've got a record of who has final staircase to make sure that you're not continuing with these repair obligations after you need to? So again, another admin approach. How will you deal with that? How will you keep track of all of that? So these are just some sort of points that both Mark and Dominic did touch on. But it's really important that you consider these and decide how you are going to deal with them in practice.
Thanks very much, Stavrina. And yeah, so everybody, I hope that was of use. I've just been looking at the questions that have been coming in, and unsurprisingly, we've had quite a lot of questions, and unsurprisingly, a lot of them focus on the initial repair period, as we suspected they would. But extremely helpfully, Dom's been actually responding to some of the questions as we've been going through. But I think they're quite useful, and so I think I'm going to go through a few of them and just read out the question and Dom's response, because I think everybody would benefit from hearing the questions, because they will be relevant to everyone. So one of the first ones we've got is, if a leaseholder has service charge arrears, are we entitled to deduct this from the 500 internal allowance per year? So I think what's being asked there is, if the tenant falls into service charge arrears for, say, cleaning or grounds maintenance, something like that, could you then deduct that from their £500 yearly allowance? And I think unfortunately the answer is no. I mean, Dom said the lease does not provide for that. And I think they are going to be two separate things. You know, there'll be a contractual obligation to pay service charge, and if they fail to do that, you have routes of redress, which are to either issue a money claim or potentially, seek possession on the basis of that, and that's entirely separate to the £500 a year allowance. So I think Dom's right on that. I don't think you would be able to offset it in that manner. Another question we've had. Are we allowed to charge a sinking fund from day one to be used after the period of year 10? And Dom's response is yes, that's correct. And indeed, that's my understanding. But I think the difficulty is going to be trying to figure out, what you would have charged for a depreciation for 10 years. So that that's not being charged. Then you've only charged from year 11 onwards for certain big ticket items and things like that. So I think that is where the administration is going to be difficult. Somebody else has asked whether or not the £500 kind of rolls on year and accrues, so they could end up by the end of the 10 years with £5,000 to spend in the last year, as it were. And the answer to that, Dom, is no. It's only, you can only bring in from one previous year. So the most they would ever have is £1,000. So if they didn't use £500 and then the next year they used they wanted to use more than 500, they could take it from the previous year, but it's only ever 1 year that it rolls over. Another question is, could we just give the shared owners £500 a year to address internal repairs? That would avoid costs in accessing and assessing what is an essential repair. So there's someone saying, let's just cut the administration out of it entirely and just give them £500 a year to arrange for repairs themselves. I mean, practically, I can see potentially the attraction of that, but unfortunately, that isn't what the lease provides for. The lease provides for the tenant to notify you, and then you agree to agree a cost and to use an approved contractor. I'm sure the leaseholders aren't going to turn their nose up if you give them £500 a year, but I do have concerns about that approach in general.
I've also some of our colleagues have mentioned possible questions about the financial side of things. Just giving tenants money raises sort of interesting financial regulation questions, and certainly as far as governance and banking rules go, I think that's a non-starter, to be perfectly honest.
Yes, yeah, I think consumer credit, would potentially raise its ugly head there. So we've had another question in, does the 10-year period pass on to a new shared owner if the original purchaser sells within the initial 10 years, which is a good point. And Dom's response is yes, the remainder of the original repair period will pass to a new buyer, but they don't get a new 10 years, obviously, they just get the remainder of whatever is remaining. Another one, would the key information documents pack need to be reissued at the point of resale? So the key information pack that Don was talking about that needs to be provided to the shared owner on initial purchase, does that have to be done again if that were, when that is assigned, that lease is assigned to a new owner? And Dom's response on that is no, it is only for the first sale of brand new homes. So those are some of the answered questions we've had. I don't know if Stavrina or Dom, you had a chance to look at any of the open questions that you fancy taking a run at.
I think
sorry, after you.
No, go for it.
Well, I've been looking at the questions, and a lot of them are quite sort of technical and detailed. And to be perfectly honest, I was mentioning this to Mark before we started, that a lot of the detail, I think you're going to have to speak to Homes England to work out some of the fine detail, because they've provided these draft leases and they've drafted them as best they can, and to be honest, they haven't, I don't think they've actually given much consideration to how it's going to work in practice. And unfortunately, we can't second guess Homes England, and we have no better idea of how they think it's going to work in practice than you do. So recommendation for sort of detailed everyday questions, I would strongly suggest that you speak to your contact at Homes England to try and iron out some of these details.
Yeah, I think it's a really good point, because I mean, as Dom says, they may well not have considered the practical implications. It's a big document. There's some far-reaching changes there, and it's only us practitioners who really think, deal with the nitty-gritty of day-to-day administration and management that will actually think, well, how's that going to work? I can see this happening, and they may not well have considered that. So by raising those points now, you may well get some guidance, and then it doesn't have to be fought over in years to come in the courts or the tribunal, because of these areas of ambiguity. So yeah, it is a really good point.
I mean, we have been raising issues direct with Homes England when we think of them, but obviously we're coming at it from a lawyer's perspective, and we wouldn't even think of some of the issues that you will have to encounter in your day-to-day admin of this. So we'll do what we can and raise queries of Homes England where things are obvious to us, but where they won't be obvious to us, that it's down to you to raise them.
Yeah, well, thanks. Well, I think we'll probably leave it there in terms of questions, because I said the ones that are remain are of the more technical answer to be answered. But what I would say is that if you do have any queries or any questions, then please feel free to contact us in the first instance. If you don't have any luck with Homes England, or you just want to discuss some of the finer points. We do also have a briefing note that a number of people from the organisation who deal with shared ownership properties has fed into. So that is available to clients, and which can include any bespoke issues that you'd like covered. So if you'd be interested in us providing that service, then please contact us, and we'd be happy to discuss that with you as well. So thanks very much for joining us. It seems like it was well received by the number of questions that we've had. I hope it was of some use. And as I say, if you do have any questions or anything, just please get in contact. And I would urge you just again to fill in the feedback forms for us so we can find out. Thank you very much.